You all may be seated. We all started again. All right. We are back on the record on the matter of the child, Abigail Delora Gadare. There are a couple of different things that were set for today, and I think I did make sure that I let all attorneys know that we are not going forward with the Department of Children's Services petition today because at the last motion hearing of October the 2nd is when Mr. Jones asked to be removed from this case, and based on issues, I did determine that he could be withdrawn from representing Ms. Hubble, although she said that she wouldn't mind doing it by herself. I do know the statute is a neglect and dependency matter, and she's entitled to an attorney, so I'm going to appoint her an attorney. I reached out to Ms. Davenport, who said that she would be available as to the department's petition only to represent Ms. Hubble. And so I'm going to appoint her officially to that case. And so for that petition, we'll just need to pick a new date that everybody can be a part of. The other reason that we're here today is originally there was a motion for a motion to set aside or clarify. Let me make sure what it was.
Motion to alter, amend, or new trial.
Motion, thank you. Yes, motion to alter, amend, and set aside. Mother's Rule 59.0 for a motion to alter, amend, and or for a new trial. That is what we are going forward on today only. The mother, of course, is not entitled to an attorney for that hearing. Ms. Davenport, you're welcome to stay, of course, to hear any of that goes on for that. But that one is not the petition that involved the state or DCS anything. So I'll hear from the mother as to why I should grant her motion to alter, amend, and for a new trial. And that's all I plan to do today.
And there's also, Mom has filed a motion for Rule 11 sanctions that doesn't have a date to be heard.
Okay.
It's November 13th.
Oh, it is?
Okay, I'll probably just take that off and put it at the same time that we do the other one as well. I'll see what it's about.
I don't have that.
You don't? I don't see that in the file right now, so. More than likely, I guess it's probably so. All right. I do have, for the record, Miss Charlena Mack, who is the guardian ad litem for the child. I have Miss Ann Davenport, who is the newly appointed attorney for the mother as to the department's petition. Miss Lydia Hubble, who is the mother, is with us as well. I have Miss Susan Mader, who is the attorney for the father. Mr. Sinan Gadir. I'm sorry, I said that wrong today. I have Ms. Christine Carlton, who is the attorney for Department of Children's Services. I have Ms. Jenny Bradford, who is the DCS caseworker. And
I'm not on this case. I thought this was the 1 o'clock motion packet.
I don't think there is a 1 o'clock.
yeah, I don't have one. Have you never been on this case?
No, ma'am.
Oh, wow. Okay. All right, one more. Scratch off this red. What case do you think you were on?
Is there a case that I filed a motion for us to close that case?
Which case?
Joseph Goodner. It's on the docket outside.
I think it was a 9 o'clock case. 9 o'clock motion. We had a Goodner on 9 o'clock. Was it Joseph? And that's just, it was just on from, I don't think I saw your motion. It was just a motion. It was on my docket. Was that Goodner? Is that the same Goodner?
It is good that no motion. I didn't see a motion.
We did not see your motion. It was on for our docket for status. Was that the right Goodner? We had it on for status. Why don't you talk to Mr. Pooley, because he was here, and it's his case. And it was just on for us, for me, for status as to whether they were ready to go forward for the trial. and everybody said they're ready for trial. So that's all I did today. Sorry, Ms. Bradford. All right, but we do have.
LaQuinta Burns on CPS.
Okay, is it La Quinta?
Uh-huh.
Okay,
And Leanne Clark is here, she might have stepped out in the hall.
and she is with.
She's the FSW.
She's
Okay.
actually the assigned worker now.
All right. All right, let me go ahead and get a date for you all, just in case you might want to, because I'm not going to require y'all to stay here.
One other question, so my understanding from, I'm not sure if I heard that from Mr. Jones or from Ms. Hubble, was that she was non-suiting her petition.
She did.
Okay.
She did
So,
follow.
I think I was appointed on her petition, but I think generally the court's policy is that if there's a petition pending regarding a child, then both attorneys get appointed counsel. I just wanted to verify that before I worked that.
Yes, because there
Okay,
still
that's
is,
what I assume.
you would still be on the case because
Okay, I
it's
just
a
wanted
DCS
to make sure.
petition, and he is
It's
the
just as
father.
to the DCS petition. Okay,
Correct.
thank you.
So you would still be on that petition. All right.
And
I'm
then-
assuming that we'll need about a day, just knowing how these cases normally take. Does
I
it
think
make
you
any
better
difference?
schedule 2 days,
Yeah.
because I'll have a significant amount of testimony and evidence. And witnesses.
All right. Can do. So as to the department's petition, how about February the 28th and March the 1st, all day?
I am available.
I'm not available those days, Your Honor.
Which one are you not available?
February 28th and March the 1st.
Neither one?
Neither one.
All right, the following week, March 4th and March 6th.
I can be available on those days, Your Honor.
Yes, for me, Your Honor.
I can do 3, 4, 3, 6.
All right. So for the DCS petitions as to Abigail Gadir, we will do March the 4th and March the 6th all day. I will set it for a status. So status would be, that's March, so the beginning of February, we'll put it on the February 5th motion doc for status. And that's just, everybody again does not have to come, that's just for status to make sure that we are ready to go forward on the trial. I do have a feeling, I'm sure I'll see you all before then anyway.
Now, regarding the DCS folks, Your Honor, I had them to be here in case there's anything that comes up about services offered or.
Okay.
Do you-
I don't
You don't
imagine.
think?
I think it's just.
I think
if it's
that was
emotional
part of
driven,
the
legal argument.
disposition. I think what I'm hearing here is just total oral argument. I don't think I need any testimony. or
Okay,
anything.
okay. I just want to make sure before we let them go. I'm sure they're glad to get back to us.
On those March 4th and 6th, they're beginning at 9, Your Honor?
Yes, ma'am. All right. All right, Ms. Hubble, so we are left then with your motion as to,
Well, Your Honor, I think we have some, I have some, there's some preliminary matters
all
to.
right,
For one thing, we needed some clarification of the order from August 17th. There were some questions about that.
okay, which motion order are you referring to?
This is the August 17th, did we hear August 17th on the father's motion? For to stop the phone calls and supervised visits and his request that I have.
All right, what is your clarification? That's
Oh,
what is
well,
it?
there's several things that we have.
Okay, well, let me, before we get there, and I'll see, because technically I'm here only on your motion to alter and amend. So that's something different, and I'll see if we can.
Okay, well, if I need to file a different motion for that, I can do that. I just thought it would, just in the sake of judicial economy, since everyone's already here, that it would be.
We probably can, but let me do your motion. Let me take it one at a time and do your motion to alter, amend, and or for a new trial.
Well, and in relation to this, I have questions also about the August 17th hearing we had. I need to know if, it's confusing. I need to know if after you hear and decide on the motion to alter or amend, if I'm ready to go ahead and go to an appeal or for the new trial. And
Okay, well, let's get to the motion to alter and amend, and then we'll take it step at a time. One step at a time. So tell me why you think I should alter, amend, or give you a new trial.
I would like to go through, I've got a very lengthy motion, and I've got a significant amount of it within this motion. I don't know if you had a chance to read it or not.
I have read some of that.
Okay, well, then I think it would be appropriate that.
It's your legal argument. This is your time to argue why it is that I should grant that. So it doesn't, what's in the pleadings is not argument. It's just to help the whoever the trier fact is to know what the pleadings are, but you have to argue on the record what your arguments are.
Well,
Unless you want me to.
I can't really argue without referring to the things that are in my motion.
That's fine. You can refer to
Okay.
things in your motion.
First of all, I believe you should alter or amend your order from April 19th because there are several errors in here. And one thing, you referred in your order, in your April 19th order, to the 2015 order. And since you did that, I think for the record for appeal, I would like to submit a copy of the statement of evidence from the first trial into the record in this case to be as an exhibit, since you referred to it in your order.
That would be something that you can attempt to do when you appeal that. That's not something that I needed as a copy of my records. That's something that on the appellate level that you can handle at that time.
Okay. Because one thing that you referred to, you said that there was no material changes in circumstances, and as a matter of fact, there were many material changes of circumstance. For one thing, we stipulated to a material change of circumstance at the beginning of this trial, just as we did stipulate to a material change in circumstance at the beginning of the trial in 2015. So your finding that there was no material change in circumstance, I think is inconsistent, because you, in the first trial, you decided that there was, but we stipulated to it, so there wasn't really anything for you to decide to. You accepted our stipulation, and then in this case, I'm not sure why the reason for the inconsistency there, but
All right, let me hear what the other parties. Were you part of this, Ms. Mader?
No, that's what I was for a second thinking about is, my position on the motion is it's moot because we're having a new trial anyway. Like, we're literally having a new trial. But I'm here, I guess.
Okay.
I'm sort of wondering, like, if I need to be here for this portion of it, because I am representing my client on the DCS petition and previously on Mom's petition.
Okay.
And so that's, as
So
we
this
started, I wasn't part of this trial.
Gotcha. So this was
Nor was
Mr.
I.
Yeah, this was Mr. Frakes. It was first Ms. Race and then Mr. Frakes. All right.
Yes.
And so as to that portion,
Your Honor, respectfully, as to a material change of circumstances in regards to the order in April of 2018, I would agree with the court, because that was my argument, that we had not had any progress from the October 2015 order, so there had not been a material change of circumstances, and at the beginning of this at the beginning of that process of the new petitions that were filed, that was the same argument. No one agreed that there had been a material change. The position of both counsel and the father's counsel and myself was nothing had changed because we had not moved past the.
So there was not a
There was not
concession
an
of-
agreement
okay.
as to there being
Your
a
Honor,
material change.
if we need to, I've got my computer, we could look at the hearing, we can go back.
I'm not, I'm a, if.
So
I'm a-
you're accepting her word that contradicts mine without any proof?
No, I'm accepting what my finding was, that there was, and then when I do my findings, I do go back over all of my notes and look through that. And so this is my finding. There are occasions that I could be wrong, but if I have an attorney that is supporting what I found, based on what I looked at and the proof and the evidence in my notes that I did, and I did not see in the notes where there was a concession of a material change in circumstances. So that's what I'm basing on. Not that Ms. Mack said it, but because I believe that, I wrote that, that's what I put in the order. I believe I was accurate. And so I'm going to deny it on that ground. You are happy to appeal, and if I'm wrong, the Court of Appeals will let me know.
Okay.
All right, your next one?
Okay, aside from the stipulation, the material changes, and it's my understanding that material changes of circumstance aren't just limited to issues that existed during the first trial. So with the material changes, there's several, and I'll enumerate them for you. Aside from that, the stipulation that we made, I'm not sure why you didn't note that. The father's failure to adhere to the order regarding visitation is a material change in circumstance. He has failed to adhere to court-ordered visitation in September and October 2016, and also this past summer, he refused an entire month of court-ordered supervised visitation without permission.
All right, and so let me first say that this order was done April of 2018, so anything that happened April 2018 would not be covered by this motion.
September and October 2016.
All right, and so I'm gonna go ahead and deny that as well because I heard that evidence previously and did not agree with that evidence as was in my order. And
So you're saying you did not agree that he refused court-ordered supervision despite testimony of the visitation supervisors, Tracy Rose,
Correct.
that said that he refused to set up visitation with them?
Correct.
Okay.
All right, next.
Okay, so you're just refusing to.
I'm refusing to hear this trial
acknowledge-
over again. And if there is an actual error that I made, other than just a disagreement, you can disagree with everything that I wrote in the order. That's your right to disagree, and that's why we have the appeals process. So you can totally disagree with everything that I wrote, and you have the right to appeal that and ask the Court of Appeals, yes, it goes to the Court of Appeals. If they could totally side with you and say, yes, that judge was totally wrong, she's got to come back and do it again. So there's okay for you to disagree with what I decided, but unless you can show me where I made an error, then there's not a need for a motion for a retrial. So going through the same facts over again doesn't mean that it's going to change.
Well, this has been drug out over 2 years, so it's possible that between the year and a half that you forgot some of the testimony and evidence that's in the record.
Well, as I said before, okay.
I will refer to, another material change in circumstance is the father's attempts to obstruct the relationship between the father and child, the mother and child. And in Ray TCD, it was the mother attempting to obstruct the relationship between the father and child. So it was a similar campaign of interference by one parent in the parent-child relationship with the other parent. So what I would refer to as evidence of that is in the record is besides refusing to schedule any court-ordered visits in September and October, there has been entered into evidence as an exhibit in the trial, an email sent to Tracy Rose, the visitation supervisor with Calloway, that the father sent to Tracy Rose before the November 26th visit was scheduled, which the November 26th visit was.
And so that evidence was already introduced into the trial?
It is.
Then again.
It's in the record. I'm just reminding you of that.
Then again, I took that under consideration when I
Okay.
did the trial, and that is not enough for me to change what I did.
Well, the motion to alter or amend allows the trial court to correct any errors as to the law or facts that may have arisen as a result of the court overlooking or failing to consider matters. That's from Chadwell versus Knox County, Tennessee Appeals Court, 1998. So I'm just wanting to make sure that you've got every opportunity here to correct anything that you might have overlooked or mistakes you have made. And in Ray Samuel P., Court of Appeals 2018, it said, as long as the judgment has not become final, the trial court may alter or amend either on its own motion or at the request of one of the parties, as it may change its mind. It may change its mind after reconsidering the proof and the applicable law.
Okay, so I will tell you this, I have not changed my mind.
Okay?
So unless there's an actual error in something that I did, not a difference in opinion on what my decision was, but there was an actual error, I will listen to that, but I have not changed my mind.
Well, okay. Rather than the...
Excuse me, I apologize for interrupting. I am scheduled to be downstairs in 1 minute.
Okay.
And so I did give Ms. Hubble my business card. I wish that I could stay. And clearly, we're going to need to meet, and I need to get a copy of the court file.
All right, and I just signed your appointment order, so
Okay.
it's all there
Here's
for
the
you.
things. Sorry, this motion. Yeah, so that's...
Well, is this regarding this motion or the DCS petition?
It's the case. Well, just, maybe you don't need it.
Yeah.
I'll meet with you.
Yeah.
Thank you, Ms. Davenport.
Thanks,
That's one reason I would like to have some clarification on what DCS is involved with.
I guess that's a similar question to mine, and when that was happening, I think that was a material change petition, not a dependency and neglect petition.
Correct. He did have private counsel, but you were technically not appointed to represent him on that. So the only thing you're appointed to represent him on is the DCS petition. I'm not doing any of the DCS stuff today. So technically, it's just the only parties that are involved now would be your client as representing himself on this petition, unless y'all have made an agreement for him to represent, and then Ms. Mack and Ms. Hubbard.
Okay.
And I'm gonna cut this short because what you're reading to me is things why you think I made a mistake. I'm not gonna go through this again. I have gone through the order. I've read it. I do not think that I made a mistake or I'm not changing my mind. So if you will look through your motion and see where you think there is an error, not just something that you disagree with, but an actual error. Because if there's not, I'm going to deny the motion for a new trial. So I'll give you like 2 more minutes to look through and see where you think that there's an actual error in what I've done.
All right, so you're telling me that you did not bother to read this motion before the hearing?
I have read your motion before.
You have read it, so you
And
know
there's absolutely nothing
everything
in
that's
this.
in here. Okay, so you're saying that
There's absolutely
none
I'm
of
not
the
reading
things
anything
that I consider to
jumped
be
out at me to say, ooh, I was wrong. Let me change my mind. Absolutely not.
okay.
Now, if you get, I read a whole lot of stuff over a long period of time. And so if there's something that you think that I actually made a mistake in, you can point that out to me, and I will look at that again. But as I'm looking through everything that has been articulated in your motion was articulated in your trial, and I didn't agree with you then, and I'm not changed my mind at this point.
Okay, well, I would like to make sure that you acknowledge that you know that the father requested a 5-year no contact order between the mother and child that was denied in circuit court, and you don't consider that to be any kind of interference in the mother-child relationship.
That's not the standard that I'm looking for. When I did this hearing, I was looking at whether there was a material change in circumstances. That did not, in my, what you all have been doing, the orders of protection and all the behaviors that led up to us coming to the court anyway, did not mean there was a material change in circumstances. That's what I found.
Okay.
That this stuff had been happened prior to, whether it was a 1-year order of protection or a 5-year order of protection. These things have been happening since the beginning that I've had review of this case, and that is not a material change.
But it's all been one-sided. I have not attempted to interfere in his relationship with the child in any way. I also think that the father insisting that he has approval of supervisors, visitation supervisors, I think that's contrary to your order, because in your 2015 order, you gave discretion of supervisor determining the appropriate topics for mother to discuss with child. You left that discretion up to the visitation supervisor, but Tracy Rose testified, and we admitted that email into as an exhibit, that the father was attempting to supersede the visitation supervisor's discretion. I felt like that was significant.
Okay.
And that you overlooked that.
And I listened to that evidence the first time. I'm not listening to it again. Again, that's a decision that the Court of Appeals can determine. I messed up, and that I need to, if they do it on remand, and that's something else I should consider.
Okay, one thing that had changed was the order of protection that father obtained that allowed no contact between the mother and child between June 2015 and June 2016. It expired. And the ability for mother and child to have contact again due to the expiration of the order affecting the child, that I felt like that was a change that affected the child in a meaningful way, and that you, because it afforded the juvenile court an opportunity to allow the child to enjoy a close and continuing relationship with the mother once again. So I thought that was something that you would have considered, that was a change that had occurred from the since the 2015 order was made.
All right. Once again, that is something that I did consider, as that was proof that was presented at the time of the trial, and it did not sway me that would be enough for being material change of circumstances.
Okay.
And today, I still don't think that that's enough to make a material change of circumstances.
And you don't believe that it is in the child's best interest to have a close and continuing relationship with both parents?
That is not something that I'm saying. What I'm saying again is that the standard that I have to look at is whether or not there's a material change of circumstances. And once I find that there's no material change of circumstances, then that's pretty much all that I can do at the time.
Also, the child's expressed desires and preferences, especially when coupled with other circumstances such as the other parent's troublesome interference and failure to encourage a close and continuing relationship between the child and the other parent, or struggles at school which have occurred since the previous order, which signal a material change in circumstance that affects the child's well-being in a meaningful way. And this I'm referring to Scoggins versus Sorg and Scoggins versus Scoggins. So when taken together, they constitute a material change in circumstances which justify a modification in custody. One thing that you mentioned in your order was that the child had been having problems in since the 2015 order. However, there was an abundance of, there was just a very dramatic difference between the testimony of the assistant principal from the 2015 trial when she was in kindergarten and the testimony of the assistant principal and teachers and the testimony of the school psychologists who did a psychoeducational report between that was enormously different. The results and testimony regarding the child from 2015 by Kimberly Schletzer, where the child had been found to be, there were no concerns about her social emotional development.
Right. I'm going to stop you there because you're going over the same evidence that I heard the first time. I have not changed my mind.
I'm just for the record, I want to make sure.
For the record, I'm going to make this quick. I'm going to give you one last opportunity to tell me something that is actually a mistake, not a difference of opinion, but actually a mistake. All the stuff that you're telling me that was presented at trial, I listened to it at the trial. I reviewed my notes. Yes, it was a long, drawn-out proceeding, a long trial that went through different attorneys and different time periods, but all of this evidence was in my notes, which I reviewed and made my decisions as to what I thought was whether there's a material change of circumstances. I made that order. What is the mistake that I've done? Not a difference in opinion, but what is the mistake that I have made?
Well, I think all of those were mistakes. But
Well, I know you do, and I
Appeals.
think that Court of
That's
Appeals
fine.
has the absolute right, and that's what their job is, to determine whether or not I've messed up. And I think this is a perfect time for them to do that. Is there anything else before I close this case?
So after you hear this, it'll be ready to go to the Court of Appeals.
Correct.
So this is severed from the DCS case. The DCS case.
Correct.
Okay,
It's a total different case.
Let me see. There's something in here. I do believe that there is no legal authority to order supervised visitation to protect the parent from the child, which is what Ms. Ballard from Progressive, that's what she had recommended. She made it. Her testimony was that
Again,
the
this
child
is part
was.
of her testimony.
Excuse me.
This is again part of the testimony that
No,
I already heard.
this is part of the law too. I would like to know if this is what your legal authority is. If it's just if you think this is a discretionary issue, because the law does say that on 366406. I think that's the one I was looking for. But regarding the restrictions of parenting time, it's supposed to be, there's supposed to be definite evidence presented to show that unrestricted contact
I have found evidence over
would
and
harm
over
the
and
child.
again.
Well, what could you specify? Because
I cannot,
that's
because
what I would like you to do. Is what is the harm? If you're supposed to, you're
Ms.
supposed to
Hubble,
state
I'm
with
not
specificity.
I have stated with specificity for the last 4 or 5 years the things that I think that you need to do in order for you to have unsupervised visits. And in fact, I thought you had gotten it and had gotten to the point where you could have unsupervised visits, and I was granting that on a very minimal basis, and something happened where I had a separate hearing and heard further evidence where you are not quite where it needs to be, and I gave reasons for that, and I don't have to do that again on this motion.
Okay.
So for your motion for a new trial, I have given you an opportunity to tell me where the mistakes are that I have made. as to the motion. That having seen that there are none, the relief you are seeking should be sought in the Court of Appeals. Therefore, I'm going to deny your motion for a new trial. This is a final hearing, and so you've already been to front of the Court of Appeals before, so you know the proceeding and what you need to do for the Court of Appeals and the transcripts and all that stuff. And I will sign your request to send it to the Court of Appeals for them to determine whether or not I've made a mistake.
I checked downstairs for the notice of appeal, and they didn't have one, so I didn't know if there was one on the computer that you could pull.
I don't have any, so
Okay.
that's the clerk function. They can figure out where it is and how you do it.
Okay.
That would be the court's order.
Can we move on to these?
Okay, what was the other thing that you were asking about?
Well, I was asking for clarification on you might just want me to file a motion for that to.
Probably, since I did, you probably should just talk to your attorney. You can tell me real quick what it is, and I can make a determination if it's something
That's one thing I had a question about is on August 17, that was for, it was my understanding that was the father's motions. So I wasn't understanding why DCS was involved in that, because it was not their petition or their motions that was being heard that day, it was the father's. So I'm just confused about when.
I don't know who was partying why and where everybody was at right now. I don't have that right in front of me. But the decisions I made were the decisions at the time. And if the father's attorney or the father wanted to call DCS as a witness or whoever they wanted to bring in as to why the visitation should be suspended, then that's the right that they have to do that. So you have the right to call in witnesses on your behalf when you disagree with some things, and whether they're part of the actual petition or not, they can be called as witnesses. And I'm not sure if that's what happened, if DCS was just called as a witness or what the deal was, but.
Okay, and so you said that the statement, you're denying my request to enter the supplement to the statement of evidence as a exhibit. You're telling me to submit that to the Court of Appeals. So I'm objecting to that.
I don't know exactly what you submit to the Court of Appeals. That I can't give you legal advice on that. You can.
But you
talk
did. You did deny.
That is not my.
You
yes.
denied my request to submit this as an exhibit.
Absolutely. Yes.
Okay.
All right. That'll be the court's order.
If we could be clear, Your Honor, as to the findings of facts and conclusions of law for the purposes of this Rule 59.04 motion that would possibly go up on appeal, so it doesn't get remanded back down for those findings, can you draw an order in regards to why, Your Honor, or do I need to do that?
If you could do that for me.
Okay.
The bottom line, all of the issues that were brought up by the mother were issues that were considered by the court during the trial. There are absolutely no new issues as to the time period. There are no evidence of any mistake. I can't remember what else is in the motion for. It's mistake, fraud, or something else. There's no evidence of that was argued by the mother. It was just simply a disagreement in the court's final decision based on the evidence that was presented during the court hearing. A disagreement by the court's decision is why we have the Court of Appeals, so the appeals process. And so this is more properly should be argued as a appeal of this court's decision and not a motion to set aside.
And you did also state that what I was trying to present as previously unavailable evidence, which was the father denying court-ordered parenting time this summer. You said that you would not consider any previously unavailable.
Not considered previously. That evidence was not previously unavailable. That had not happened
okay.
At the time of the trial. So I'm not considering anything outside of the time period that the trial was had and the order was done.
Thank you very much.
All right.
We're finished, Your Honor.
I'm
We're
finished.
saying your findings and conclusions of law were.
That's it. I can't remember what else. Mm-hmm.
Okay.
But based on those findings and if you can set out what the motion to set aside, what the statute says, the reason to grant a motion to set aside. This is a conclusion of the law based on those findings of fact, and then the law that says what the motion to set aside, Rule 59 says, there is no evidence as to a need for to set aside or a new trial. All right, anything else? All right, that'll be the court's order. Meet you downstairs.
Can everybody please exit the courtroom, please?
Thank you, Ms. Carlton, for staying.
Exit the
Thank you
courtroom.
for it, okay. That was on my way out. Why is there so many cars today? You know what?
So